Okay, we're all back. Make sure my mute is on my stream. All right, let's be on the record in case number 2018 CR 989, captioned State of Kansas versus Emmanuel Dickens. Would the parties announce their appearances, please?
May it please the court, Karen Whitman for the state.
May it please the court, Mark McLaughlin appears for Emmanuel Dickens, who appears by Zoom.
All right. We are here set down for a plea. I think the first thing I ought to do is ask the parties, has there been a prelim or a waiver in this case?
There has not, Judge.
We should
It was
probably
set for August 4th.
All right, we should probably start with that. Mr. Dickens, your lawyer tells me we're here for a plea today. One of the things, a separate right you have besides a jury trial is called a preliminary hearing. That's a hearing early on that the state would have to put on enough evidence to prove to a court there was probable cause that a crime was committed and that you committed that. Basically, that there's a reason to keep going until trial. If we're going to do a plea today, there's really no sense in doing a preliminary hearing, but it is a separate right. And if for some reason you decided at the end of this plea or at the end of this hearing not to plead, then if you've already waived your prelim, you're not going to be able to take that waiver back. So do you have questions for me or Mr. McLaughlin about any of that?
No.
All right. And do you want to waive your prelim today?
Yes.
Mr. McLaughlin, on behalf of your client, do you agree with that?
I do, Your Honor.
All right. And Ms. Whitman, for the state, do you waive prelim as well?
Yes, Judge.
Okay, fantastic. All right, that'll get us, I'll show that both parties waive prelim, bind the defendant over for trial, momentarily enter a not guilty plea on his behalf, waive formal reading, Mr. McLaughlin.
Yes, Your Honor.
Okay, all right. So we're going to take up this plea, Mr. Dickens. To do that, I got to ask you a lot of questions, and I'm going to have you sworn in to do that. But before I do that, let me tell you that if you don't understand something I ask you, you tell me that and we talk about it until you do understand, okay? I don't want you guessing at answers.
Okay.
The other thing is, if at any time you want to talk to Mr. McLaughlin in private before you answer a question, I'll give you that opportunity. You just tell me and we'll send you off to that room just like we did a moment ago, okay?
Okay.
All right. So now if you'll raise your right hand, my court reporter will swear you in.
You solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
All right. Mr. Dickens, how far did you go in school?
The 5th grade.
All right. Do you read and write okay?
A little bit.
Okay. So I know and I'm going to pull it up here in a second. There was a thing called a plea petition that you and Mr. McLaughlin worked on. I don't know if you worked together or if he sent it to you separately, but did you have a chance to look at that document?
Yes, he showed it to me.
Okay. Could you read it or did he read it to you?
He read it to me.
Awesome. Okay. So I take it you understood everything in it?
Yes.
All right. Now, as you sit here today, I know you're in custody, but are you under the influence of any alcohol or drugs or prescription medicine that might cloud your thinking, keep you from understanding what we're doing?
No.
Feel like your mind's clear today?
Yes.
Good. All right. Do you know what you're charged with?
Fleeing and eluding.
All right. And you understand you don't have to change your plea from one of not guilty to guilty. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial on this. Do you understand that?
Yes.
At that trial, Mr. McLaughlin would assist you. He would have the right to confront and cross-examine all of the state's witnesses, and he could challenge all of their evidence. Do you understand that?
Yes, sir.
He would be able to call any witnesses you wanted called, and if they didn't want to come to court, he could use the subpoena power of the court to make them come. Do you understand that?
Yes, sir.
During that trial, you would have a right to testify, but you'd also have a right not to testify. And if you decided not to testify, the state couldn't use that against you to argue that you're guilty. Do you understand that?
Yes, sir.
All right. Now, at the end, if we had that trial and at the end you were convicted, you would have a right to appeal that conviction to an appellate court. If you didn't have the money to do that, a lawyer would be appointed to do it for you. Do you understand that?
Yes, sir.
Now, if we go forward with this plea and you end up pleading guilty today, you're going to be giving up all of those rights and there's not going to be any kind of trial either before a court or a jury. Do you understand that?
Yes, sir.
All right. Now, I talked about that plea petition. I'm going to bring it up here on our screen so we all can see it. Can you see that document, Mr. Dickens?
Yes,
Is that the one that Mr. McLaughlin read to you?
yes,
Okay. Now down here where it says what the plea agreement is, it says this, that you're going to plead guilty to count 1, which is the felony fleeing and eluding. And the state is going to agree to recommend the low number or the mitigated number in your sentencing box. The state and defense counsel believe that you are criminal history I, which is the least severe criminal history, that they both will recommend the standard probation of 12 months with court services. Is that your understanding of the full plea agreement?
yes, sir.
Has anybody else promised you anything other than that to get you to plead today?
No, sir.
Anyone placed any force or threats against you to make you plead today?
No, sir.
All right. Mr. McLaughlin, is that your understanding of the entire plea agreement?
It is.
And Ms. Whitman?
Yes.
All right. Now I see in here, Mr. Dickens, that it says a couple of things about sentencing, that they're going to agree to recommend a low number in the box, what they believe your criminal history to be, and that you should receive probation. Now you understand that while I listen closely to everybody's recommendations, I'm not bound by any of them, and I can give you any sentence that the law allows me to give you. Do you understand that?
Yes, sir.
Okay. Now, they say that your criminal history I, and if that's correct for this case, you're going to be clearly in presumptive probation and a pretty low sentence. But you understand that until there's a pre-sentence investigation, the court doesn't know what your criminal history is.
Yes, sir.
Okay. So that what that means is that for today's hearing, I have to assume you have the very worst possible criminal history so that I can advise you that the most that anybody can get for this crime. Does that make sense?
Yes, sir.
Okay. So the most that anybody could get for this crime is 17 months imprisonment and a fine of $100,000. And that sentence would carry a post-release supervision duration of 12 months. You understand that's the maximum?
Yes, sir.
All right. Mr. Dickens, do you have any questions for me about anything that we've gone over so far today?
No, sir.
All right. Mr. McLaughlin, do you know any legal reason why your client should not plead guilty?
No, Your Honor.
Then I'll ask you, Mr. Dickens, as to count 1, the felony fleeing and eluding, how do you plead, guilty or not guilty?
Guilty.
All right. Mr. Dickens, I'm going to ask Ms. Whitman to tell me what she thinks the evidence in this case would be. I want you to listen closely because when she's done, I'm going to ask you if that's what happened, okay?
Okay.
Ms. Whitman.
On June 16th of 2018, a trooper with the Kansas Highway Patrol who was in a fully marked Kansas Highway Patrol vehicle determined that a Nissan Maxima's registration did not return to that vehicle. He activated his emergency equipment to stop the vehicle near I-70 and the I-635 interchange, and that Nissan failed to yield. It continued at a high rate of speed. It was over the speed limit in 3 different speed zones. During the chase, he failed to maintain a single lane more than 5 times. He failed to stop at stoplights over 5 times. He eventually ran over some stop sticks and yielded to the emergency vehicle. And he surrendered. The driver, who was later identified as Emmanuel Frank Dickens, was placed under arrest. All these events occurred in Wyandotte County, Kansas.
Yes,
All right.
ma'am.
Mr. Dickens, I heard you say that. That's what happened in this case?
Yes.
All right. I will find the defendant has freely, voluntarily, and intelligently entered into his plea of guilty today. He understands the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis for a finding of guilt, and I will in fact find that Mr. Dickens is guilty of fleeing and eluding. I'll order a pre-sentence investigation and continue this case for sentencing pending the receipt of that. I'm looking, folks, at September 18th at 10 o'clock. Mr. McLaughlin, how would that look for you?
Sounds good. September 18th at 10. Got it.
Ms. Whitman?
Yes, Judge.
All right, that's what I'm going to set sentencing for. Let's talk about bond. Is Mr. Dickens being held on something, anything else?
I spoke with him, and I believe everything else was released. I was hoping, since I believe he's been in a couple months, that he could, and I spoke with him about the importance of making sure he shows up for sentencing, for his pre-sentence investigation. As far as that, he could be released on his own recognizance today.
Ms. Whitman?
My only concern, Judge, is he doesn't stop for law enforcement. If he fails to show up at any of these things, are we going to have another one of these? That's my only concern.
All right.
And
So
we went
Mr.
over, and I
Dickens,
went over that. I went over that at length, just letting him know of the seriousness. And I think just sitting in jail for these last months, he had a lot of time to reflect and learn about the importance of, when it's time to show up, for authorities, that he'll actually show up. So I think he's fine with that.
all right. Mr. Dickens, I think it sounds like everyone believes you're going to be presumptive probation. So there's really no sense in making you sit there longer. So I'm going to give you an OR bond. But here's the deal that I always tell defendants. And, most of the time it works out, but sometimes it doesn't. Sometimes they're looking at a pretty good deal and they're going to get probation and things are going to go really well for them. And then they get out and do something silly. And they end up not only catching a new case, but blowing their sentence in this case. So really the safe kind of thing to do is just to have you sit there. I don't want that to happen, but I need you to be able to tell me that, you're going to show up when I need you to show up and that you're not going to get in trouble between now and sentencing. Can you tell me that?
Yes, I can. I will be here, and I have my sister to bring me down here.
Okay, so here's what we're going to do. I'm planning on doing this just like we're doing here. We're trying with this pandemic going crazy still, we're trying to limit the number of people here. You need to keep in touch with Mr. McLaughlin, because if we're going to set it up for a Zoom, you're either going to have some internet access somewhere, or maybe come to his office, or hopefully we'll have some other arrangement in the court. Or if we need to, we can all get together in person, but I need you to show up no matter how we do it. Okay.
Okay.
All right. So sentencing is going to be September 18th at 10 a.m. And I am going to release Mr. Dickens on an OR bond today. Mr. Dickens, I do have to advise you, as a convicted felon, it's prohibited for you to own or possess a firearm and certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons.
Okay.
Particularly before sentencing, but really anytime in the future, before you decide to own or possess any kind of weapon like that, talk to a good lawyer like Mr. McLaughlin. Make sure it would be reason for new charges or to have a probation revoked, okay?
Okay.
All right, we will see you all on September 18th at 10 a.m. Mr. McLaughlin, I'm thinking that I should just make you the administrator and leave you and Mr. Dickens here together to do that PSI, or did you already do that?
I got the information at the breakout session. So
Okay.
yeah, we're fine. So I'm gonna email this shortly.
Okay, and you got myself and Miss Hutchins over at Court Services email, right?
Yes.
I put it in the body of the email when I sent you
Okay.
a copy if you didn't see it.
Okay.
But
So
anyway.
yeah, I'll get that.
Okay, fantastic. Other things for our record today?
Nothing, Judge.
No, Your Honor.
Everybody have a great weekend.
You
We're
too.
adjourned.
you.
All right. Thank you, sir.
Thank you, Ms.